As the court pleases, Chief Justice, Deputy Chief Justice, and Justices, I had my protected 10 minutes. It was planned, but I'm going to change time.
You're waving?
No, I'm definitely not waving. Certainly not. I'm just rearranging the structure in the light of the discussion that has taken place. I was going to talk really about what I would call the triad of cases. That when the book on executive accountability is written, this triad of cases, EFF Nkandla, secret ballot case, and this one should feature prominently, and talk about the interrelationships between those cases. But the primary interrelationship is the one that has already been discussed here, which is between this case and the primary interrelationship between this case and the Nkandla case. To put it colloquially, at the risk of overgeneralization, from the discussion that has already taken place, it's very clear that should an impeachment process take place, either as a result of the concessions that are made or whatever, the Nkandla judgment will, for lack of a better word, form part of the indictment. And I think the Chief Justice was alluding to that, the fact that it does form a basis. Obviously, the Public Protector's report would also form a part of that indictment. But there's also an interrelationship between this case and the secret ballot case, located particularly in the first 5 paragraphs of that judgment, where the duties of accountability are outlined. I won't paraphrase it for the sake of saving time. Then I was going to deal with the 5 questions that need to be answered in our view. 3 of them are quick questions that are just preambular to the 2 that I will propose are important. The first question is almost a rhetorical question. I don't think even my learned colleagues will dispute this. Is there, as we sit here, a prima facie case of impeachable offenses? The question answers itself, yes. Now, if so, question 2. What obligations are triggered on the part of the National Assembly and the Speaker? And that's section 42, 55, and so on, and 89. And have those obligations been refused, denied, and so on? And the correspondence which was touched upon will show that the answer to that is yes. Otherwise, we wouldn't be here. If that's actually the dispute. The dispute is that he said, she said, the EFF says in their letter, put the effective mechanism. The Speaker says, I won't do it because for whatever reasons. But the point is that she refused to do it. Which then takes us to question 3. Are the justifications put up by the Speaker to refuse that request, do they hold any water? And they will deal with that. Then those are what I call the preliminary questions. The real question, as far as I'm concerned, in my submission, is, in the light of all that, what interpretation must be given to section 89(1) in particular? And does the interpretation that we give to section 89(1), the so-called 2-stage theory, that there has to be a fact-finding stage, inquiry, and the voting stage, again, to put it generally, can that be assailed? Is there anything wrong with it? Is it more consistent with the Constitution, and so on and so on? and we will humbly submit that it is, that absent such an inquiry, actually 89-1 will be an empty shell. And then, of course, the last question is the whole question of remedy, which is complex in this case, remedy, separation of powers, and so on. And on the last question of remedy and separation of powers, I must agree with Mr. Nguraitobi that that question, if you have regard to our heads, in the first 2 or 3 pages, we actually separate the relief into categories. There's what we call the declaratory relief and the directory relief. It is exactly for that purpose, because the declaratory relief has a life of its own, and then the directory or mandatory relief obviously raises questions of separation of powers. So those are the issues. But what I wanted to change with my free time was to try and preempt some of these questions when nobody can take me on, as it were. And one of those questions is this, asked by the Chief Justice. What stops the parties themselves from going to the Speaker? Well, what stops them, Chief Justice, is the fact that she has refused in so many words. Therefore, I think the letter says, therefore I refuse to accede to your request, just as she did in the secret ballot case. So it's exactly the same wording. And that happened after 3 attempts, not a year ago, Chief Justice, but over a period of about a year, actually. The first request came in April, the second one came in September, and the last one came in February of this year. So it is no doubt that these papers were actually served on the anniversary of the Nkandla judgment, because at that stage it was, well, we've now tried everything, it's a year, nothing is happening. What is to be done except coming to court? And that is the context. The second question that related to a question of the Chief Justice and Justice Zondi about the framework and the necessity of this inquiry. The answer is that actually examples, if we take what we call the schematic overall unitary interpretation of the Constitution, I will refer the court to sections 177, 194, and 196 of our Constitution as the reference points from which this court can distill the necessity of the fact-finding inquiry. Section 177 deals with the impeachment of judges. Section 194 deals with the removal, I think, of the public protector, and the other one about people of the Public Service Commission. There are others. There's even about the police and so on. But I'll confine myself to those 3. In all those sections, there is one constant. And this is where we will say Section 89, how Section 89.1 should be interpreted. That constant is that there must be, in the one case, the best example is the one of judges, because it's closer to our case, because it talks about gross misconduct. So the whole adjective of gross or serious is part of it. In that case, the scheme is very clear. If Justice Kabinde was here, I would have referred to her, because she and I were involved in the inquiry of Judge Jansen. It's simple. Somebody complains and says, Judge X has said this, and then there's a fact-finding inquiry under the auspices of the JSC, which is what I was participating in. And then after that, then there's the whole story of the 2/3 and what have you, and then the president must remove. In all the other instances, it's exactly the same. So,
The 10 minutes is up.
oh,
And maybe in the course of your explanation, you must just bear in mind that a statute provides for all that,
I know.
and nothing stops Parliament from regulating
Absolutely.
its own processes the way it wants to. It doesn't have to be a court doing that. Possibly.
Yes, yes, Chief Justice, and neither am I, by any stretch of the imagination, suggesting that we should just transplant those. There are idiosyncrasies in each of those. But I'm saying at the level of principle, to impeach on the basis of misconduct, of doing something wrong, as unlike the motion of no confidence situation, you cannot escape the fact-finding stage of inquiring into whether or not this has happened or this has not happened. It's inescapable. Of course, as we know, there might be exceptional cases and all that. In this case, this happens and so on. But as a matter of principle, how do you say you are being impeached on the basis of gross, or rather serious violation of the law, serious violation of the Constitution, or serious misconduct without any inquiry? It's the same, it would be the same as saying to an employee, you can be told that you are being fired for misconduct, gross or otherwise, or you've breached the policies of the company, but you know what? You must just go. Well, that used to happen in a particular era, but certainly not in the constitutional era.
Mr. Mpofu, may I ask you a question on another issue, but one that should come
Yes, Deputy Chief Justice.
earlier, but I think it might be quite close to the center of this matter.
Ask God, please.
Parties or litigants, everyone is expected to only approach courts when there are no other means to satisfy their disputes or resolve their disputes. That obligation exists in relation to the lowest of our courts. It should follow that it's even more pronounced when you are going to approach the highest court in the land, that you should try and resolve issues if you can without going there. Now, the Speaker, one of the points she takes in her answering affidavit, which I mentioned to Mr. Ntobi, is that she says, but you people, you are rushing to court about something that you can get through the processes of the National Assembly by simply using the rules of the National Assembly. And then Mr. Ntobi says on behalf of the EFF, well, we did make a request and she refused. And of course, I said, well, that request had certain features about judges, and she said that's not provided for anywhere in the Constitution or legislation. But as I understand the position, one of the points she makes is this, that it was open to any of the applicants at any time to initiate a substantive motion and ask the National Assembly to establish a multi-party ad hoc committee that would do exactly this investigation. And I have not seen anywhere in the applicant's founding affidavit, anywhere where they say, we did introduce such a motion, and either it did not succeed or she frustrated it. And the question then is, if indeed that avenue was not tried by the applicants, is it in the interest of justice that this court should, for example, grant direct access when that was not exhausted?
Yes, as court pleases. Deputy Chief Justice, that's very important, because that actually goes into the simple issues of, because you can't just come to court. What is the dispute? Parties only go to courts when there's a dispute. Let's unpack the dispute. The dispute will be found at pages 162 to 170. That's the correspondence. And then one of the letters that is, I think, is at 256.
162.
162, that's JM 11.
Just give me the page reference, 162 and?
And 162 to 170, Chief Justice, to 170. That's the correspondence. But one of the letters is found in the answering affidavit, so it finishes that series at 256, just a one-page letter. Now, what do you get when you look at that in a paraphrased form? The EFF says, well, this was 4 or 5 days after the judgment of this case. There has been a judgment. You have power, you have duties under sections 42, 55, A and B of the Constitution to scrutinize and oversee and so on and so on. Parliament should provide all the necessary mechanisms to ensure that the executive organs are accountable. And the last part of that letter is very important. However, they say, since the President is not an ordinary member, an independent disciplinary inquiry that is impartial, free, fair, transparent, and open to investigate his misconduct and violation of the Constitution. That's what we're asking for. That's all. An independent inquiry that is free and fair, that will look into his violation. On the next page, then they do an attempt of a kind of a charge sheet. These are the charges. 16th November, he did this. On the 31st March, he did this. He landed a plane in Waterkloof, Waterview, and so on. And then the last paragraph of that letter is important. Parliament has the duty to satisfy itself that it has put, as mandated by the Constitution, every mechanism possible to hold the executive accountable, hence the importance of an independent process. What is the answer to this clearly correct demand, as they put it? It's not even a request, they say it's a demand. The answer is no, to paraphrase it. I'm not going to do that.
But I know I'm interrupting you,
yeah.
But the Speaker's point, as I understand it, is that you don't have to ask me. You can just initiate a substantive motion in the National Assembly, and you must tell me if I misunderstand.
No, with respect, you do, Deputy Chief Justice.
But I'm not now referring to what she says in the letter.
No. I'm simply saying that her reply has 4 elements. The first one, she says there is no provision, no provision in the Constitution, the law. I'm not talking about this case that came up yesterday. That's a different thing, which we object to, by the way, to be presented with a new case on the eve of the, but that might be a question of costs or whether or not there's a room for settlement and so on. But on the case is here. She says there's no provision in the Constitution, the law, or the rules that provides for what you're asking for. Actually, Section 89 and 102 provide for instances, blah, blah, blah. That's the first ground. The second one, she says, the rules that you are talking about don't apply to the President because he's not a member. That's not just, that's a serious objection to say he's not a member, therefore you must go somewhere else. The third one, she says, Even if the disciplinary process of the assembly applied to the president, such a procedure could only be conducted through the existing mechanisms of the assembly and not through an external process. That I will grant her. The issue about the judges and so on. And I agree fully that actually, but I don't want to go into a side issue, there is nothing stopping the National Assembly from delegating its power to 3 judges or whoever they want to delegate. The JSC actually does it. There's a case of Mutata where that point was taken and it was dismissed. Because it's still the National Assembly per se, but the National Assembly might say, look, we don't have the expertise. We need an accountant and a judge or whatever to do the fact-finding. It will still come back to us. But when that body of judges is operating, it is actually the National Assembly conceptually. So that objection is wrong in any event, but that's not the point. And then the fourth part, she says, remember, it's a member and so on. So it's very clear. Then when the second request comes in September, she probably thinks maybe these people don't understand me properly. The last, she says, I refer you to that letter, but the last sentence, for the stated reason, I am unable to accede to your request. In other words, no again.
Was it still asking for judges to be involved? The second one.
Yes, no, they were not. The second one, which was I don't have a copy of that letter, Chief Justice, but that request seems to have been muddled up with something else about preventing the president from addressing the parliament and so on. And then there was a reference back to that request. So she deals with that first issue and then says, with reference to the matter of dismissal proceedings, I wish to refer you to my response of 3rd of May, which is the one I read out. But in case you don't understand what I'm saying...
Before you get there, I'm sorry, the Deputy Chief Justice is still with you.
I'm sorry. Yeah.
Did the second request include or exclude the involvement of judges? You see, it's important.
Yes, I know it is. Can I come back to that, Chief Justice? My understanding is that the reason why she says I'm referring you back to the old response might suggest that it was a similar request, but I'll find the letter. The point I'm making at this stage is simply that she says no. Then on the now in the 1st of February, they write again. Please, we want the disciplinary inquiry. And this one is at JM 15, page 169, Chief Justice.
Disciplinary inquiry that is being asked for, not an investigation.
No, I'll come to this question. I think there's a terminological problem between an investigation and an inquiry. I'll come to that.
Because I just heard you say we want a disciplinary inquiry, so I just wanted to make sure.
Yes, it's an inquiry, definitely.
Disciplinary.
Yes, yes. And in this one, at least to answer the question, even if the other one I was wrong, this one I've got on the 1st of February at page 169. There's no reference to judges at 169. Yes. It says that it talks about the sections 42, blah, blah, blah. You did not respond affirmatively to our demand, and up to this stage, no action of any kind has been taken for violating his oath of office, continued disregard, and so on and so on. And again, this is rejected.
Well, they do say, I'm sorry to interrupt you, Mr. Mpofu, in the second paragraph, although they don't refer to judges, they say, we specifically asked that you institute an independent inquiry that is impartial, free, fair, transparent, and open to investigate misconduct and violation of the Constitution by the head of state.
Yes, that was also in the first letter, so that's a neutral fact. But in the first letter, they then went to say who must chair it. So
maybe let me ask, I'm sorry to interrupt you. When the EFF was referring to an independent inquiry, would that be would an ad hoc committee of the National Assembly be an independent inquiry?
Yeah, yes, in a sense, Deputy Chief Justice, because when an ad hoc committee of the National Assembly sits as a disciplinary inquiry, its independence must be assumed. In other words, if I'm from Party X and I'm sitting in that inquiry, I have to listen to the evidence in the usual way like everybody else and so on. It might well be that when I get to the House, and now I'm partisan and all that, I can say all sorts of things. But there's no ways that you can say, for example, in that inquiry, no, you're not allowed to cross-examine. No, you're not allowed to answer.
Well, Mr. Pofu, whether a body is independent or not depends on a number of things, one of which is how it is composed.
Yes.
Okay? Now, an ad hoc and multi-party ad hoc committee of the National Assembly would include opposition parties.
Yes.
Opposition parties opposition parties, and some of those parties, and I don't know if it's all, but some of those parties have had quite a difficult relationship with the person that would be the accused, if you want to say that. Would you say that that party would be seen as independent, that inquiry would be seen as independent?
Maybe before you answer, even the ruling party, what are they independent of? Who is independent of what?
Yes. The point is this. When a body, in fact, let's again take it to the labor law sphere. If I'm subjected to an inquiry at work, it's made up of all the managers. So at face value, they're obviously not independent because they work here. They are the bosses. But if they deny me the right to cross-examination, for argument's sake, and this and that and the other, I can go to the labor court and say, that so-called inquiry was a kangaroo court because it did not exhibit the sufficient levels of independence qua inquiry. So, and we're not examining a statute here. It's a letter from a member of parliament for all it is. So we can't now go to the dictionary meanings and so on. The point of the matter is that they were asking for something other than just the normal sitting of the National Assembly.
You know what, before the Deputy Chief Justice comes in, you know what my difficulty is? Once you refer to judges at first, and subsequently without qualification refer to independent, logic dictates that we must tie up the reference to independent to those judges who are not members of the National Assembly. It becomes difficult to divorce the previous request for the involvement of judges from the expression independent or from the word independent. Well, that's the difficulty that I'm grappling with.
No, I accept that, Chief Justice. But another way of looking at it, which is equally competent, is that in the first letter, you refer to judges. You were told that no judges are going to come here. So in the second letter, you don't, because you now have been told. So we can't say which of those two prevailed. The point, what we know is that it was omitted this time around. But really, the point I'm simply making is that there were constant refusals over a period of a year. And a party, once that happens, a party has no other option than to approach a court of law.
No, I understand that, Mr. Mpofu.
Yeah,
I'm just wanting to come back to the question of what is the request that was made in the context of the point raised by the Speaker of saying, but what you want, that you are asking the court to
can be accommodated,
is something you can get through using the rules in the National Assembly. So now that's why then we go to the letter to say, in the second request, they said they didn't mention judges expressly, but they said it was an independent inquiry that they wanted. Now, going back to the question of independence,
Yes.
I may be wrong, but I do have some suspicion that a lot of people might not see an ad hoc committee of parliament made up of different parties as independent, particularly in a case relating to somebody where, for example, it is known some of the parties have been saying, but he's not fit to be president.
Yes.
He's not fit to, he's guilty of serious things
Yes.
already before, and that is known to be the stance of a particular party or
Yes.
certain parties.
No, I understand.
And I'm not saying they are not entitled to that stance. I'm simply saying if one is now looking at whether an ad hoc committee would be independent, those are some of the...
Yes, if that is the case, then all what we are here for counts for zero, because then there should never have been an SABC inquiry. There should never have been an inquiry on the Nkandla document, because inherently the parliamentarians can't have an independent inquiry. Well, Deputy Chief Justice, you are correct. There might be people who hold that view. I'm not one of them.
But you must understand, I'm trying to understand.
Yes.
You know, because the Speaker says what they are asking for, they can get here. And insofar as you are talking about an ad hoc committee, I think the Speaker is not, at least the latest stance, is not one that is against that. Yes. But I'm trying to see whether, when the second request said independent, whether it was, EFF was having in mind an ad hoc committee or another kind of committee.
Well, I'll answer it differently, Deputy Chief Justice. A reasonable speaker who wants to hold the executive accountable would have asked the very same questions that the Deputy Chief Justice is asking me. What do you mean by independent? Does that include an ad hoc committee? And so on and so on. That's what you do when you want to hold the executive to account. That's the first answer. The second answer is that that stance, as you correctly qualified, DCJ, only comes yesterday. This stance that, so it might well be that on this new stance, as far as what we call the mandatory relief is concerned, I'm almost sure, we'll talk to my learned colleague over the lunch break, I'm sure that on the yesterday stance, then we can find each other there. So we can't be held, why are you here, about something that happened yesterday, with respect. The third answer is that, contrary to what she says now, Deputy Chief Justice, and that will have to be taken into account both in the substance and on questions of cost and so on. Contrary, she actually said the exact opposite in her letter. She said there is nothing in the rules that provides for this. Two, the man is not a member, and therefore, so that is the exact opposite of what she's saying yesterday.
I think you are right in terms of what she said in the letter.
Yes.
But I've also had a look at the affidavits of both the EFF and the Speaker in relation to this point about the President not being a member. Yes. Both, she said in her reply that the President is not a member of the National Assembly and therefore he can't be subjected to
in her reply to the letter.
Yeah, that's her reply. But when the EFF responded, or rather I made a request later, they also adopted the same approach, which was that yes, he is not a member of the National Assembly. No. And well, we can go there.
It's 162.
162.
Yes.
Okay.
The EFF said something completely different. It said it was referring to the Powers and Privileges Act. It's the bottom of that letter, where it says, ordinarily, if the President was an ordinary member of the National Assembly, he would have been charged through the Powers and Privileges and Immunities Act, blah, blah, blah. And then it says, however, since the president is not an ordinary member, an independent disciplinary inquiry, and so on. So there's a qualification, and he is not an ordinary member, by the way. But the other contradiction, Deputy Chief Justice, is actually even in the stance of the Speaker. So you're quite correct, because later you remember that in the answering affidavit, when they quote Rule 85.3, they actually underline the part that says this and that rule, including the president. So it was a self-contradiction.
No, it's true. When you examine her answering affidavit, when you read certain parts of the answering affidavit, she seems to accept that the rules apply to the president, even though he's not a member.
Absolutely.
But when you go to another part of her answering affidavit, she says she incorporates into her affidavit the letter that she responded with, where she was saying the president is not a member.
Exactly.
So there is some contradiction.
There is.
There.
And even after the third request, this one of February, she keeps on referring to the letter that said he's not a member. In fact, in all the answers, she keeps on referring to that.
But doesn't this tell us that there is a problem
I would agree.
in Parliament? These parties are not talking properly to one another. They're not talking to. How can people that we now know are quite close in terms of what can be done? How can we have a situation where for so long they had this matter pending, and all they needed to do is to have talked more? And if they have talked more, there's no reason to think that agreement could not have been reached.
Well, Deputy Chief Justice, with respect, there is. The reason is simply this. That must have been the attitude of the EFF, that we'll send this thing in in April 2016. She says no. We'll send it again in September. She says no. We'll send it again on the 1st of February. She says no. What do? There comes a point at which the rebuffs must be resolved by a court of law. The fact that yesterday, 24 hours ago, the Speaker then comes and says, actually, this can be done, is the very same thing that happened in the Nkandla case. For months and months and months and months, it was payback, the money, this, that, and the other, until we were here on this very podium. Then the solution came. And so if that Nkandla court action had not happened, we might still be at a place where we're saying recommendations and all that. The point is, there's nothing more than the immediacy of the court that appeared to have sobered the mind.
Just the last point from my side to you. It's not correct that she only took that point yesterday. She took the point in her answering affidavit, but in yesterday's or recent supplementaries, there was just more elaboration. She did take the point that the rules, and she referred to a number of them, including Rule 85. Provide for this.
Yes, but that's wrong. The Rule 85, we've dealt with that in our heads. Rule 85 has a big heading about rules of debate. So it's got nothing to do with what we're dealing with here. So Rule 85 is, at least on our version, inapplicable. So all we can go with is that if the Speaker of Parliament says the rules do not apply because he's not a member, and therefore I'm not going to do it, then who are you to say, well, apart from repeating yourself? So with the greatest respect, until the stance, and the stance of yesterday is much stronger with respect, and is correct, because it says, what you are asking for can be done within the existing mechanisms. And by the way, the reason why the parties were asking for it is because they must have believed that it can be done within the existing mechanisms. So there's no revelation there. The revelation is only on her part because she thought it could not be done.
I'm happy that you said during the lunch break, you and your learned colleague representing the Speaker will talk.
It's our professional obligation.
I think that the lawyers might well have to show the political parties that some of these matters can be resolved.
Can be done. No, with respect, it's our professional obligation when it comes to, because the court must never really easily be placed in a situation where it has to deal with separation of powers issues, if it can be avoided. That is our duty to ensure that it doesn't even arise. And I suspect that we will. Which would then say, leave us with the declaratory relief, assuming optimistically that Mr. Maneche and I will find each other.
In line with what I hinted when you came to see me.
Yes, as the court pleases. The declaratory relief, then actually this then places us squarely in the zone of what I was beginning to discuss. The declaratory relief, in my respectful submission, really revolves around one thing: the interpretation to be given to Section 89. That's all. Whether or not, as I submitted, the fact-finding stage is inherently built in that section, or whether it can be avoided. I would submit that, and let's look at the question, let's take the Chief Justice's question and invert it a little bit. If the DA's motion in April last year had succeeded, the Chief Justice asked, would we be here? I would propose, Chief Justice, that yes. The only difference is who would be the applicant and who would be the respondent. Let me explain.
I meant the applicant. Would the applicants be here?
Let me explain myself. Firstly, before I explain that, let's first understand what brings us here. It would be disingenuous of us, with respect, to think that we're here to vindicate the president's Audi rights and all that. Please, that's not what we're here for. The fact that he will get his Audi rights is a happy coincidence. But what we're here for is what is described in the first 5 paragraphs of the secret ballot case. It is to vindicate the right of we the people. We the people need to know. We cannot just have our president disappearing with some wishy-washy process. The president, if he has to, there's a quotation from the DA heads that made me laugh. Apparently, ironically, this was said by President Nixon, where he said the people have a right to know whether their president is a crook. Now, we are not vindicating his rights, we are vindicating the rights of the people. The people must know if a president has done the things that is alleged to have done, are they serious violations? Do they amount to impeachable offenses? And so on and so on. More so, Deputy Chief Justice and Chief Justice, when 89 goes much further than anything we've ever seen. It has what I call a triple whammy of punishment on the president. One, he loses his benefits. Two, he loses his right to hold office ever. Let's assume this was a 30-year-old president, may never hold a public office. And thirdly, I suspect because of the interpretation, he even loses the title. You'll see that in 89.2, it says, 89.1 says the president does this and so on. Suddenly in 89-2, it says, anyone who has been, so you've just become anyone now. Anyone who has been deprived of this will not have the benefits and so on. So it's one of the most serious, you just become a person in the street. Now, in the light of that, if you assume the people are a fair people, can the people really say that a president must just be removed just because 2/3 of people who might have been bribed or whatever it is
Mr. Mpofu, you should send a bill to the president for arguing so well for him.
No, I'm leading up to this point, which really is what I'm trying to say. Which is the Chief Justice's point. Let's assume for a minute the DA's motion had been successful. If I was the president, or as Justice Madlanga...
You are not declaring your aspiration.
I'm not declaring the future, no, Chief Justice. But, okay, let's say if I was the president's representative, and he was impeached as a result of the DA motion, I would say, piece of cake. Because we can go to court and say to the court, okay, so you've impeached us. How did you know that we are guilty of serious misconduct? How did you know that we are guilty of seriously violating the law? How did you know that we are guilty of gross misconduct? And the answer is not, with the greatest respect, Chief Justice, in the Nkandla judgment. Because the Nkandla judgment, as it is, actually does not provide that answer. On the contrary, the Chief Justice said for the court, at paragraph 83 of the Nkandla case, that I'll paraphrase, that the president might have been acting on the wrong legal advice. He might have been I'll come to the right passage. It's better to paraphrase it. And so on and so on. So this inquiry that we're talking about is exactly the opportunity to answer those questions. And with respect, it's not just the Chief Justice or the court. Even the public protector, in certain passages, which I won't go into, she says, for example, when he allegedly misled the parliament, he might have been acting bona fide. I couldn't establish this, blah, blah, blah. 83, yes, paragraph 83 says, this is what this court says. The president thus failed to uphold, defend, and respect the Constitution as the supreme law of the land. This failure is manifest from the substantial disregard for the remedial action against him by the public protector in terms of her constitutional powers. If the court had stopped there, then the Chief Justice, with respect, would be correct. What more do you want? But then it says, he was duty-bound to, but did not assist the public protector and so on. This is the important part. He might have been following wrong legal advice and therefore acting in good faith, but that does not detract from the illegality of his conduct. And the reason is simple. This court was not looking at those questions. Whether he was bona fide and so on, it doesn't matter. For the purposes of this court, there was a breach of a constitutional duty. Now, we know, and the court might well take judicial notice on this, that, for example, there is a suggestion a strong suggestion in the public protector's report that at other parts that he did so knowingly. In his public apology after the Nkandla judgment, he said, "I did not knowingly." That's exactly the point. That dichotomy between the findings that he did something with his eyes open and saw the fire pool and saw all those things, and the version, his version at least, which at this point has to be accepted, that he did not do so knowingly.
Let me know when it's the right time
Convenient. When I finish just this sentence, Chief Justice, that very dichotomy is what needs to be inquired into. And before Chief Justice, there's a case from in Kenya, which I will, with the permission of my learned colleagues, maybe send to the court afterwards, where this point is made exactly because the justices there say that not all constitutional violations are gross. In their statutes, it doesn't say serious, it says gross, but that's the same thing. And it says, therefore, just like you do when you have something, where there's all these adjectives, assault to do grievous bodily harm, who must determine whether it's grievous or not grievous? Obviously, it is the fact-finding body that is tasked with that. And here, that's all we're saying. The seriousness, or whether or not it was because of a bona fide. If it's bona fide, for example, if I was representing him, Justice Madlanga, I would say, well, in these cases, it's not a serious violation. But if it's found that it was knowingly, then I would agree with the appellation that it was serious. And I would go as far as Justice Madlanga did in the DA case to say it was justifiable, albeit in the context of elections, to say he stole the money. And that was because there were so many findings that were obviously not meeting the criminal standard, but that were sufficient to say there's something wrong here. This is the convenient.
No, thank you very much, Mr. Mpoof. You know, isn't it the responsibility of the National Assembly to arrive at the conclusion whether or not there's been a serious violation of the Constitution or the law? It is, isn't it?
Oh, certainly.
Now, fortunately, we're not arguing in a vacuum. There is history, some history here. The impeachment process alluded to already. The question and answer sessions flowing from the Nkandla judgment. Can we deduce from all that put together that the EFF, the DA, COPE, and UDM had reason to doubt? Did they articulate or allude, even remotely, to the possibility that what the president did was not serious? I'll tell you where I'm coming from. Yes. I believe that all the parties, council, and the court are not involved and are not to be involved in a situation where this is what is happening. Oh, we wanted to deal with him through an impeachment process. We wanted to deal with him through the question and answer session. We missed him. Let's try again. Court, get involved. Maybe this time we'll get him. That's not where we are.
No.
Now, is there any doubt to be deduced from any of these parties that they ever doubted the seriousness of the failure articulated by this court as a violation
yes.
of the Constitution of the law, so that we have something that undergirds
yes.
the prayer for an order to establish a structure that will engage in a thoroughgoing investigation? Because if there never was any doubt, and if there is no doubt, from those who are ultimately going to decide if we were to authorize or to order an investigation, those who are going to ultimately decide whether or not this was a serious violation of the Constitution or the law, what are we doing?
Yes.
If the EFF does not doubt, and if the parties you represent do not, as we sit here, doubt,
Yes. Well,
who then is going to step into their shoes and say, no, 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 you may not doubt, but there's a doubt, therefore let the president come and say something, and what are we dealing with?
No, no, Chief Justice, with the greatest respect, that question, with respect, that does not arise in the context of what we're asking for. Because just like a complainant in a rape case, she has no doubt whatsoever that she has been violated. But that does not, it cannot stop either the police or the courts from doing what they have to do. So to ask the complainant, do you have any doubt? No. Therefore what? Then let's hang him.
Please,
No.
please bear with me.
There must be a
Yes.
process.
Yeah, no, please bear with me on that score so that as you continue, there's no misunderstanding between us. I'm saying it remains the responsibility of the National Assembly to hold the president accountable.
That's good, please.
And it appears, and I put it no higher than that the EFF, the DA, COPE, and the UDM were so convinced that what the president did constitutes a serious violation of the Constitution or the law that they did not hesitate. About what? 6 days after the Nkandla judgment, to have a motion rolling, debated, and voted upon. They participated in that debate. Why? Arguably because none of them saw a need to still check, oh, maybe this is not serious after all. It appears there's room for asserting that as at that stage, as they put questions, as they debated, they were confident.
Yes.
They were convinced. So what are they now saying? That they didn't know, what, they were not satisfied back then, and they have since or maybe they were satisfied now upon further reflection, they are no longer satisfied.
Yes. No, now I understand the question, Chief Justice. There are two answers to that. One, if as sure and confident as they might have been, if we are correct that that process that was followed is wrong in law, if we are correct that there needs to be a two-stage, there needs to be a finding of the fact that the wrong, unlawful process was followed, even if it was followed 10 times, is neither here nor there. Because we are coming to the court to say the correct process, which is called upon by our Constitution, is that there must be a fact-finding inquiry. So it could have been done 1,000 times, and they might have been very, very convinced, but that counts for nothing. That's the first answer. The second answer is that, as a matter of fact, and my learned friend at this stage might object, as a matter of fact, when the debate happened, these questions arose. The other side was saying, no, it's not serious. Others were saying, no, it's serious, and so on and so on. And others said, there's even an article by a certain Mr. Jeffries, who's the Deputy Minister of Justice, where this question says, if the Constitutional Court thought this thing was serious, it would have said it's serious, blah, blah, blah. So that's exactly the point, that my own take, and I'm happy for it to remain speculative, is that the court deliberately did not want to stray into the separation of powers and say this is a serious violation. But that was used opportunistically as a defense in the actual impeachment proceedings to say, of course, then it means it's a mere violation. And remember, the Chief Justice even said he took legal advice and so on and so on. That's exactly what needs to be inquired into.
No, before we move on, let me just put this question to you. Do the parties you represent who have strong footprints in the National Assembly doubt the seriousness of the violation of the Constitution? Because it's only then that you know, we would have well-grounded basis for granting your order. If they doubt, so let's hear and let everybody hear.
Yes.
That
No.
whether your clients say this is serious or it's not serious.
No, okay, before I answer, and I will answer, Chief Justice,
Sure.
Let's go back again to basics. We are not asserting even the rights of the parties here. So whether they doubt or don't doubt is their business. The rights of the people as embodied in the accountability scheme of the Constitution is what is at stake, as this court clearly set out in secret ballot.
Yes.
The parties might believe whatever they want to believe. The point of the matter, that's the first answer. The second answer is that one has to distinguish between the parties, as the Chief Justice rightfully says, as part of the NA, but also as complainants, so to speak, in wearing another hat in impeachment proceedings. So, with the greatest respect, if we are indeed vindicating the rights of the people, whether Party A, today it might be Party A or Party B, their own beliefs become irrelevant.
Okay, now let me explain myself. I was moving from this premise that we're talking about not ordinary members of the public, but key players and members or structures that have representation in the National Assembly. Now, thinking broadly, it ought to be in circumstances where they, as members of Parliament, are not satisfied that there has been a serious violation of the Constitution of the law, that they say, no, we need an investigation, we need clarification here. There's some violation, or there appears to have been some violation. We don't know whether it's serious or not. It's our judgment call as the National Assembly to say whether or not there is a serious violation. We are not able, we need more facts or whatever, more assistance in relation to the interpretation of the Constitution and the law to conclude that there has been a serious violation of the Constitution and the law. That's where I'm coming from, because if nobody doubts that there has been a serious violation of the Constitution and the law, on whose version are we then setting up a structure to inquire into, among others, whether there has been a serious violation of the Constitution and the law? That's where I'm coming from.
By shorthand, by reference to paragraph 83, again, of the Nkandla judgment. There has to be some level of doubt. There has to be, otherwise it would be, they would be crazy or out of their minds not to. When no less than the highest court of this land has said, it might have been bona fide, then the doubt is inherent. The doubt must be there, because the doubt has been sowed, with the greatest respect, even by this court, and the doubt has been sowed even by the public protector. In fairness, because those bodies were simply saying, look, we are not the criminal courts, we are here for this or that and other. And it may or may, by the Chief Justice or the court saying it might have been legal advice, you are not saying it is. It might have been, it might not have been. But that's exactly what needs to be inquired into.
So these parties, as members of the National Assembly, want to satisfy themselves whether or not there has been, among other things, there has been a serious violation of the Constitution or the law, because they have a doubt.
Yes, or a mere. There might have been a serious violation or a mere, let's call it a mere violation. And I'm just using that term to distinguish between the situation of bona fide and malafide, for example. And I'm using this just as an example. There are various other things about the degree of seriousness and on all that. But I'm just using paragraph 83 as an example. So the degree of seriousness, which is what is envisaged in 89(1)A and B, by the use of the adjectives serious in both sections, they are therefore pregnant with the need for the determination of the degree of seriousness. And that degree of seriousness, among other things, is a function of whether the violations were done knowingly or not.
I'm probably repeating myself, but I just want to round up this thing just so that there's clarity in my mind.
Yes.
So when members of the National Assembly, or those members of the National Assembly who were involved, set the ball rolling, say, no, there's a case for impeachment here. They did not as yet believe, as members of the National Assembly who must make the judgment call, they did not as yet believe that there's been a serious violation of the Constitution and the law, as they don't now.
No, Chief Justice, with respect, let's differentiate conceptually two things. That they subjectively,
As members of the National
yes,
Assembly.
as all of the
Yes.
but subjectively, that they might have, when the president says, for example, in the public address, I did not knowingly violate the Constitution.
I'm sorry, just so that I don't put the question to you.
Yes.
As they initiated this, as they debated this, and as they voted,
Yes.
they did not objectively believe that there has been a serious violation of the Constitution.
No, Chief Justice.
I just want assistance.
Yes, let me assist Chief Justice. I'm saying, if when the president says, for example, I did not knowingly do this, and you can be sure that they said, oh no, he did. He says he didn't know. He did know. So at that level, obviously, they knew that he did. But the point here, the importance of the question in the constitutional sense is this. They were entitled as complainants, whatever they believed, like the example of the rape victim, whatever they knew, whatever they knew in their heart of hearts, but they were entitled to say, well, insofar as the other side is saying there was consent, well, then a court of law or a fact-finding process and so on. We know we're going to be vindicated, but a process must then objectively determine whether we are right or not. And it might not. And that has got nothing to do, by the way, with whether the person was raped. They might still be acquitted. But the point of the matter is that for that person to be taken to jail, the trigger has got to be a fact-finding process called a criminal trial. For the employee to be put on the street, the trigger must be a fact-finding inquiry called disciplinary proceedings. For a judge to be put out to pasture for life, there must be a fact-finding inquiry called impeachment proceedings. For the public protector, and so on and so on. You cannot escape the need for the objective determination at some stage of the jurisdictional fact of what the section says must be done. Otherwise, it's exactly what this court said. These instruments might as well be thrown out into the dustbin. They are useless, they are ineffective, nobody will ever be impeached according to them in our lifetime. Because every time that person would say, but you have never determined that I've violated the Constitution, let alone in a serious one. And therefore, and now you are putting me out to, then we might as well strike out Section 89. If it does not insist on a stage that gives the right, yes, to the accused president, but to the people themselves to know, the right to know whether or not that person is, remember, they voted for that person. Remember, so they have a right to know whether he's now being removed because certain MPs, 2/3 of whom have been bribed, have just voted, or in fact, there has been a gross violation. That is what we're here about, Chief Justice. With respect.
So one must understand the position to be that the 27 question and answer sessions by the same National Assembly to the same president who needs to be given the opportunity to be heard were not sufficiently thorough. They don't have the same effect as constituting an ad hoc committee or some other structure where questions would be put to him and possibly the same questions, and he would answer.
Yes. Yes.
We must assume that, more will be achieved by creating a structure where similar questions will be put to him to afford him to respond again.
Yes, two answers again. The first one is, on the facts of this case, those so-called question and answer sessions actually are part of the problem, because that is where the lies were allegedly told.
And the truth will be told this time around.
Of course. When there's a question and answer, this court said itself in the secret ballot case, I'll get the paragraph now, that there are various mechanisms. It mentioned question and answers, and so on, and so on. Yeah, and then it said, this court said, but there comes a time when those mechanisms are insufficient to hold the executive accountable. When that time arrives, then the twin peaks of accountability, motion of no confidence and impeachment may be invoked. So this court itself recognized, Chief Justice, that the Q&A is insufficient, and quite frankly, if I was a president who's impeached and they say, but how did you know? You say, oh, no, remember there was a Q&A, so that's how we knew that it's serious. Then I would again win the case, because I would say, I need nobody can just come and say, I lied about the bond. How do you know? I've not been cross-examined by anybody. I have not been asked to bring a copy of the bond. Nobody has said, where is the affidavit from FNB or what have you? But now you're telling me I actually did not have a bond on the basis of what? Question and answers. No, I need those things to be ventilated in the same way as an employee and all the other examples.
But if on the information available, it is possible to arrive at a conclusion, yes, it's possible for members of the National Assembly objectively to arrive at a conclusion whether or not there's been a serious violation of the Constitution and the law, would you still need the additional factors of bonds and lies and whatever?
Yes. No. Then I understand your question, Chief Justice. This is the answer. Let's say, postulate, this is probably will never happen, that in the Q&A, member X says, you, President, to use the extreme example that the Chief Justice took, you shot and stabbed somebody in the course of a robbery in downtown Johannesburg last week. And the President says, yes, I did. Of course, naturally. And at that point, the National Assembly might say, look, we have a Hansard record. And it would go back to the question that your Chief Justice was asking Mr. Ngcukaitobi. Well, in those circumstances, what's there to investigate? But we're not dealing with that. We're dealing with the exact opposite, where the Q&A has not struck oil, where all these other mechanisms, as postulated in the secret ballot case, have failed. And the time has arrived for, otherwise, let's say, okay, let's do nothing. Well, he has, as the Speaker always says, he has responded to the question, which is a different thing from answering the question. And therefore, let's leave it. No. What needs to be done is, if mechanism 1 doesn't work, you go to mechanism 2. If impeachment doesn't work, well, I don't know what will work.
Yes. You know, I hope this will be my last question or statement, because I've been with you for a long time now. So, not 27 questions. 27 sessions. 27 sessions.
Correct.
of putting questions on the same subject matter could not help extract what was sought to be extracted.
Yes,
They proved not to be satisfactory. 27.
Yes, Chief Justice.
And the ultimate is part and parcel of that process, which was an impeachment process.
Yes. No, an unlawful or unconstitutional impeachment.
And who declared it unconstitutional?
Well, I'm saying, Chief Justice, that any impeachment process, I'm prepared to say this without fear of contradiction, any impeachment process that does not accord the president and the people the right to a hearing is unconstitutional.
I was just summing up. Just summing up, Mr. Mpofu. So those 27 sessions on this Nkandla matter,
yes,
coupled with what you brand an unconstitutional impeachment process, were not thorough enough. It is an inquiry that will be thorough.
Well,
that's what you are saying.
Yes, that's what I'm saying, Chief Justice, because it's the same thing. Let's take the employment situation. I'm the boss. Malena Jr. is the employee. I say, did you steal the check? No. And I do that 27 times. Did you steal the check? No. Did you steal the check? No. How does that help? The point is, he must still be placed in a fact-finding inquiry as to what was the check doing in his pocket. Why did the bank say that the check? You can't say, well, I've asked.
Why can't you put those questions in those sessions? Anything?
Sorry, I didn't.
What is it about the 27 question and answer sessions that prohibited that from being done?
It's the denials. The point I'm making.
No, I'm saying, I'm sorry, Mr.
Sorry.
I'm sorry.
Sorry, Chief
You
Justice, I didn't
understand
mean
how
to
it.
interrupt.
What is it that stopped that process, or members of the National Assembly during those processes, from putting all of those questions that you say will be put at an inquiry about the bond, everything? Yeah. What is it that stopped that from happening?
I'll tell you what it is, Chief Justice. And again, I'm taking liberties that we've all watched how these things are done. Those questions are basically monologues where you ask a question and you get a response. If you try to say, no, but then they say, sit down, Mr. Gadi. Otherwise, we're going to call or switch off the mic and so on. Nobody's going to switch off the mic, with respect, in an inquiry. Nobody's going to call the white shirts in an inquiry. And nobody's going to say, you've asked that question and it has been responded to. Responded, or has it been replied to? All those deficiencies are absent in a proper inquiry, as we all know it, whether it is at the university for a lecturer who didn't go to the lectures, or this one or that one or that one. So, with the greatest respect, Chief Justice, both the magnitude and the number of question sessions, it does not help. But secondly, the quality of the process, as we all know it, is so fundamentally flawed for the purposes. Otherwise, this constitution would then say, well, when you are impeaching a judge, just ask him 27 times whether what he did, what she said on Twitter was a racist statement. And if she says no, then you let her go on and practice. No. She must be put into a fact-finding process by the JSC, properly constituted, given a chance, cross-examined, and then on the basis, only on the basis of that, the National Assembly must then vote by 2/3 majority, and only on the basis of that, the president must. The word must is used instructively there. At that point, the president has no discretion whatsoever. Once those things have been done, complaint, fact-finding, 2/3, the president must remove that judge.
Mr. Mpofu, sorry, Chief Justice, if you finished, may I put a question? Thank you. Thank you. Mr. Mpofu, we have jurisdictions across the world that when they wish to impeach their presidents, it's always preceded by a fact-finding inquiry. We have a very progressive constitution, which allows for impeachment of the president, provided there's serious misconduct or constitutional violation. And if one looks at the Constitution as a whole and the Bill of Rights, it gives fair trial rights, Audi rights, all of those things. So wouldn't it be consistent with the Constitution to read Section 89 as requiring this inquiry? Now, the question here is not whether generally Parliament needs to put in place rules that make provision for such an inquiry. The question, well, I mean, that's eminently desirable and reasonable for it to do that, and it should have done so by now. What it hasn't. Now, the question is whether we should ask Parliament to basically set in motion this inquiry.
Thank you very much, Justice. Justice Kathryn, that goes to the heart of what we are about. The first question, or rather proposition that you put, must be correct. Remember, even under the common law, one of the so-called canons of interpretation is that Audi must be assumed in circumstances like this. So why should Section 89(1) not be construed in such a way that Audi must be part of it? So that is quite correct, but let's put that aside. Your Ladyship, Justice Kathryn, you're quite correct. If, for example, touch wood, we find each other with our learned colleagues, then to accommodate the DA's prayer, what you are proposing would be quite correct. In other words, it would, and I'm just taking it off the top of my head, it should read something like this. There will be a complaint put on such and such a date. On such and such a date, an ad hoc committee will be put, blah, 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 blah. And then to accommodate the broader relief, it could say within 6 months or whatever, the Parliament must put the so-called long-term mechanisms in place. So that would be definitely something that can be accommodated within the context of this case.
Mr. Mpofu, thank you. Just 2 questions from my side. The first one relates to the nature of the 2 requests made to the Speaker. When one has a look at the correspondence carefully, it would seem that the second request is not really a request. It's simply a recordal of the first request. It's cast in the past tense. We asked you to do that. So it would seem that the first request continued to remain alive and in the air, because the second request, or the second letter, concludes really with no request relating to the inquiry, but rather with regard to the proposed hearing of Parliament. Yes. And the questions that I have arising out of that is, was there then an opportunity, if one has regard to the correspondence given to the Speaker, to consider what you say now is the request to establish a committee that would have fact-finding powers? Yeah. And then arising out of that, if there was such a request to the Speaker, was that request directed to the correct entity? If regard being had to the rules of the National Assembly, the power to establish such a committee really vests in the National Assembly, and it is to be effected through the bringing of a notice.
Yes.
And then I have a second short question just after.
Thank you. Justice Colopen, your first question, well, you know, as lawyers, all of us, we know this thing called a letter of demand. Actually, if you read the letter, the first letter, it says, on behalf of the economic freedom fighters, I write to you to demand that Parliament is entrusted by the Constitution and so on. So it's a typical letter of demand. And of course, the answer is no. So what do? Of course, any attorney worth his salt will say, I'm making a demand, you must pay my client 200,000 rand, blah, blah, blah. And the other side say, go and jump. And then they say, okay, I refer you to my letter of such and such a date to pay my client, go jump. A year later, I refer you to that request. So the request cannot suddenly metamorphose into something else. It's a request that is continuing, just as the refusal is continuous. So that's the answer to the
So you accept there was a consistency in the request, and that consistency was that we need a judge or the prosecutor to have a disciplinary inquiry?
Yes, absolutely. In fact, that could even be a point against me in relation to what the DCJ was asking. Because if you remember the exchange between the DCJ and I about whether the judges were mentioned, that would be a point against me, because once they say, look, we refer you to that letter, then obviously, even if the word judges doesn't appear, it might still be there. So there is no doubt that there was this continuity.
Maybe while you are still there answering him, was the kind of structure with the terms of reference you now propose ever requested from the Speaker of the National Assembly? That which you are asking us to make an order about in that format, was it ever presented to the Speaker for consideration?
Yes, it was, Chief Justice. If you look at page 163, as I say, let's forget about
I mean without judges. The one you are asking for is without judges, isn't it?
Yeah. No, it may or may not be. I must insist, Chief Justice, with respect, that there is nothing stopping Parliament from delegating its functions of investigation, inquiry, and whatever to anybody. So in other words, if let's say this thing concerned very complex financial questions, Parliament could say, we are now going to have a panel of the top accountants in the country, but they're not sitting as PwC or whatever.
That I understand. Yes. I don't have a problem with... I'm not arguing that. I just want to know, yes. One, in these papers, I don't understand you to be asking for judges to be involved.
No.
You? So, in line with my brother Kolapen's question, have you ever approached the National Assembly and said, we are now asking you to set up a structure, not that will discipline, but that will investigate, and these are the possible terms of reference that we would want you to consider. Have you done that? Was it rejected? And after it was rejected, only after it was rejected did you come here?
Let me put it like this, Chief Justice. Firstly, there's what I thought might have been a terminological dissonance with the questioning of Mr. Ngcukaitobi between an investigation and the inquiry. And I was thinking that the simplest way to make a distinction between those two, because I agree with the Chief Justice, in the light of these facts, when you are armed with the Nkandla report and the public, yes, there's no need to investigate in the true sense of the word. Investigate as the policing function. In other words, to investigate properly. What we're not asking for is not the investigation, the police investigation, so to speak. It's the inquiry, the court process, because we agree that that stage has been passed on the facts of this case. In other cases, it might be different, but there's nothing really to investigate. You have a prima facie case. That's why I said the primary question is there a prima facie case? If the answer is yes, and I don't expect my learned colleagues to say anything different, then forget about the investigations, the police investigation type. What you are talking about is the inquiry now on guilt or otherwise. So that is what was being asked for in the first attempt, so to speak, with all those charges, badly formulated as they might have been. The second...
have you dealt with... I'm not sure.
No, there was a second question.
Was that the second one that says a different proposal or request in line with what you are now asking us to make an order? Was it ever presented to the Speaker? Did she refuse it? And only after she refused it, you approached the Court of Law?
Yeah, well, on our version, Chief Justice, this is exactly what we were always asking for. Put aside, and I'm prepared even to go as far as to say, let's say she was right on the question of judges, just for argument's sake. As Mr. Ngcukaitobi correctly pointed out, a reasonable speaker in her position cannot simply say, aha, just because you've now suggested that this thing must be done in Bloemfontein and not in Johannesburg, I'm rejecting the whole thing. Surely, the obligation on the speaker was to say, forget this thing about judges. But what you're asking for, all these things you have tabulated about the judgment, the public protector's report must be inquired into. You might be misguided or badly advised, to coin that same phrase, about these other things. So it was severable.
I was just latching on to what Justice Colopin and the Deputy Chief Justice asked to say. Before you can go outside of the family, the confines of the family, you must have presented something that was rejected, and realizing that you're not going to find an in-house solution, you then went out.
Yes.
So that was the thrust of my question. Did you give her the opportunity to reflect on this and reject? And when you realized that she was rejecting, then you moved out?
To court. Yes. Fair question with respect, Deputy Chief Justice. The answer to that is at prayer 2 and 3. But more prayer 3, because we say at prayer 3, declaring that the first respondent has failed in her duty, failed or refused would be the same thing, in her duty to apply her mind and scrutinize the violation, blah, 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 blah. That is what we are accusing her of, to put it bluntly. And what we are asking this court, on the facts of this case, on the reading of the correspondence and so on, to agree with us that she, by the answers, the non-answers and so on, failed in her duty to apply her mind and scrutinize the violation of the Constitution by the President, and so on. If that is so, that's all really. If the court agrees with us, then the court will make that declaratory order, that is indeed so. If the court says, no, she didn't actually refuse, you misread her letters or whatever, then we're in the wrong place. The second question was about the forum. Justice Colopin. The answer lies really again, in the constitutional scheme and the role of the Speaker in that constitutional scheme. The Speaker is not a mere class monitor of the National Assembly. Her role is, the reason why the Speaker is appointed like the President is because the role that she plays is of crucial importance, and the cases have said that. The Speaker, in addition, if regard itself to rules 6 to 26 of the National Assembly, one will distill, particularly Rule 26, will distill specific empowering roles for her really to steer the ship, to paraphrase. And therefore, and that is why she is the embodiment of the National Assembly. And as Mr. Nyokaitobi correctly submitted, the duty to make sure that this happens, and in fairness to the Speaker, at no stage, even in her letters to the reply, I mean to our demands, did she say, no, you are sending this to the wrong person. She never said that, in fairness to her, because she understands that rule. That's a separate thing from saying, which is also correct, that members have a duty to initiate, trigger, complain, and so on and so on. That is also correct, but the Speaker, qua Speaker, is a special constitutional being, to coin a phrase that was used in the EFF Nkandla case.
Good, thank you. Then my last question, sorry, is just that as you and the Chief Justice debated the sufficiency of the accountability process with regard to the question and answer session, do I understand your argument to be that when someone comes to the National Assembly as a member of the executive by invitation and asks and gets to answer a question, generally that answer is dispositive of the question, as opposed to appearing before a committee under subpoena, taking an oath, where the answer may not necessarily be dispositive, and the process can be much more adversarial. That appears to be the distinction between the two processes.
That's correct. In fact, to put it bluntly, Justice Colopan, what happens in those question and answer sessions is the exact opposite of the word used in the Constitution, scrutinize. Exact opposite. Because there's no opportunity to scrutinize anything, or let alone thoroughly investigate and so on and so on. So by those sessions with respect are in themselves deficient. They can never, in my respectful submission, never, except in those exceptional circumstances where the person just confesses, they can never satisfy the need for the fact-finding stage, with respect.
Mr. Beaufort, my last question is this to you. The case, as I understand it, that the applicants brought to this court is one that says the National Assembly or the Speaker has failed to hold the President account since the judgment of this court, I think, in Nkandla. And this kind of inaction, I think that's the term used, cannot, I'm paraphrasing.
Is unconstitutional.
Yes, yeah. Now, the Speaker responds by saying, in effect, but there have been measures that have been taken within the National Assembly to hold the President accountable. She says the DA brought a motion, I think, was it soon after the Nkandla judgment? I can't remember now whether it was of removal or no confidence or impeachment, and she refers to other things. As I understand what she is saying, it seems that she is saying, but all these measures are accountability measures. They don't need to have been initiated by me as the Speaker. As long as they took place in the National Assembly, then the President has been held accountable. The fact that a particular accountability measure might not have been used doesn't mean that we must disregard all the others that have been used and then say the National Assembly has done nothing to hold the President accountable. What do you say to that answer?
Well, let me start with a concession that agrees with what you're saying, Deputy Chief Justice. In the light of that, and in the light of the answers that the Speaker has given, it is putting it too strongly to say nothing has been done. That goes without saying. But so what is the question? The question is this. As this court explained in the secret ballot case, there is a hierarchy, let's put it like that, of accountability mechanisms. That hierarchy starts at Q&A and peaks at impeachment or motion of no confidence. There might be a debate as to which one is more severe, but we know that those two are the serious ones. It cannot be, with respect, Deputy Chief Justice, that if the lowest threshold in the hierarchy has indeed been invoked, then, well, that's fine, let's go home, nothing can be done. No. That would be like saying to the police, I say, my house was burgled into, and they say, okay, we'll send someone to check, and they go and send someone to check. And then I said, but you didn't take fingerprints. They said, no, but we sent someone to check. You have, this is why we said in the letter, says the Speaker is being asked to invoke all the possible mechanisms to hold the President to account. That's the actual wording of the letter of demand. It doesn't say just do the minimum that you can do and then you're fine. It can't, because it shouldn't. It should say, and that's a function of the seriousness debate that we've been having, which I won't go into. Because the reason why, if, for example, they were saying the President had a speeding fine, then you just ask it in the Q&A, did you have a speeding fine? No, I didn't. That's fine. But if you're saying the President possibly violated his oath of office, an impeachable offense, possibly lied to Parliament, a breach of the Ethics Act, possibly misled the public protector, then you cannot just casually, in some wishy-washy Q&A session, determine the fact. That, by definition, is as an impeachable offense, belongs to a different sphere of life, namely the 89, Section 89. And that's what the Speaker would, again, in fairness to the Speaker, she knows this. Because in all her answers, she says, remember Section 89 says this. Remember Section 102 says this. So she knows that we're not dealing with a speeding fine, in fairness to her. So she acknowledged that we are dealing with the higher level.
Well, I was asking this at the level of saying what is the case that the applicants have brought to court, and what is the case that she has attempted to meet in her answering affidavit. Now, the answer you have given me, it appears to me, might go against some judgment of the appellate division. I forget the parties, but it would be early in the 90s. You might recall in the early 90s there were a number of cases that came before the AD on strike dismissals in government. Yes. Langeni was one of them. Zenzele was one of them. Or Zenzile, I'm sorry. There were about 2, 3 others. Yes. Around about the same time, there was Chaub versus administrator of Transvaal. Yes. There is a case that came around about that time where what had happened, I think, or what was decided might go against the answer you're giving me. Of course, we would not be bound by what the AD said, but we would have to examine what it says if need be. What happened in that case is that the lawfulness of the dismissal of the workers was challenged on the basis that they had not been given any hearing before they were dismissed at all. And the administrator then dealt with that case in their answering affidavit. But in court, counsel, I think it was the Ismail Mohammed, sought to argue that because the administrator said they were given a hearing, he sought to argue that that hearing that they were given was not adequate. Yes. Therefore, we must still get the order that we want. Yes. The court was split. The majority said that's not how we run cases. If you say there was no hearing, the other party is entitled to limit its case to saying there was a hearing. Yes. If you want to say your case is that there was an inadequate hearing, you must say so, and then the other party can deal with it. Yes. Smallberger JA thought that it could be dealt with on the basis that even if they argued that it was inadequate. Yes. Yes, Deputy Chief Justice, you're correct. Those labor cases, when it was still permissible to take those matters there, I remember very well. But happily, I'm in a better position than that counsel who was in that unfortunate position, because
two reasons. If you go to prayer 2, it says, declaring that the first respondent has failed to put all appropriate mechanisms and processes in place to hold. It doesn't say any. If it had said any, then that would apply, because it would say, look, the kind of you've done nothing. That's not what it says. In case there's any doubt, then go to page 15 of the affidavit. Or rather, it's probably paragraph 15. Yes. Towards the middle of that paragraph, paragraph 23 on page 15, you'll see it gives a bit of the history. The National Assembly, under the leadership of the first respondent, Justice Colopin's Point, and so on, has failed to take an action, blah, blah, blah. Then it says in the middle of that, second, it seeks an order, seeks an order compelling the first respondent to cause the taking of all the necessary and appropriate steps to determine the seriousness of the violation as a prelude, blah, blah, blah. Now, that, both the pleading per se and the affidavit, in this case, unlike that unfortunate situation, specifically is all-inclusive. In other words, it doesn't say, in a way, the minimum would be enough, because it says you must take all the mechanisms. So does the letter, by the way. You must take all the mechanisms, and here it says take all the necessary and appropriate. Surely, but surely, that must include
You are looking at us with great satisfaction. Have you?
I am. I almost
It's like you are looking for a challenge.
Chief Justice read my mind.
Yes.
Not with so much satisfaction, but at least I'm glad that we have covered most of the issues.
Thank you so much, Mr.
As the court pleases.
The court will adjourn for 30 minutes. There's the lunch break. Court will adjourn.